Well, Jordan, would you mind telling me what's new in your practice, especially as it pertains to property management and landlord-tenant law?
Sure, of course. Well, we're getting a lot of inquiries about HB 25 1090.
Okay. And what is that? What is HB 25 1090? What's going on with that one?
That's a great question. Well, the bill was originally designed to regulate advertising, specifically advertising for a rental property in the property management context, ensuring that the total cost, including all mandatory fees, were the amount advertised. But it has had very significant effects to managers and landlords of multifamily buildings, especially with regard to utility billing.
How so? Could you elaborate on the utility billing aspect?
Sure. So the bill makes some things very clear. For example, the bill says that no amount can be charged to a tenant for common area utilities. So for example, if I'm a property manager who manages a multifamily building with hallways with interior lighting or hallways that are heated, I can charge no amount to tenants for those utility costs. However, the bill does not make clear exactly how, as a property manager or landlord, I am supposed to bill back for the tenant's individual utility costs for their unit.
Do you have any recommendations as to how someone might handle that distinction?
Sure. So the Colorado Attorney General's office issued a memo on guidance last year that has been somewhat helpful. The memo at least makes clear that from the Colorado Attorney General's perspective, landlords and property managers may bill back utility cost for the unit to the tenant. They may do so as long as they meet certain criteria. There are 4 criteria. Perhaps the most important criteria is that the methodology of billing back meet a standard of reasonable and objectively fair. The problem is the memo doesn't specify what that means. And so that has left the industry guessing about what is reasonable and objectively fair.
Of course. Well, we find ourselves with the legislature convening once more. Have you seen any updates as to if they're going to give additional guidance or revise this bill further?
We have. We've seen the introduction of a new bill by the same legislators that introduced the last bill. This is 1013. The new bill specifies that billing back using a ratio utility billing system is permissible, but does not give us specific guidance on how that may happen. What's really important to remember, however, is for now, that new bill is not yet law. It has not passed into law. It has not been signed by the governor. It has not passed both houses. And so we have to wait to see what happens.
Of course. Well, we will continue to monitor that with you. Thank you so much.